Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello, ladies and gentlemen. Once again, it's hanging out with BWF Solicitors, your immigration platform. I hope you are doing well, and I believe that you are all set for tomorrow being Christmas. You know, this is our last show for 2022, and we have a surprise for you for 2023, so you watch out. Today's program, the topic is what happens to a person whose document, which is submitted during an application, is found to be false. One might wonder, putting in an application, you are trying your very best to, put in that application, expecting that this application becomes successful. So one will ask, why will one put in an application with false documents? Lawyer Eunice is here to take us through this topic, because I know it's very, very, very common when people put in an application and documents are found to be false. Then they later run to solicitors such as BWF solicitors to try and correct those mistakes. So 2023, we don't want to see our lovely viewers who put in their applications to go running to solicitors like BWF solicitors to help them correct those mistakes with false documentation. Please share this program to all your contacts, colleagues, and friends, because I believe it might be of benefit to them. My name is Vicky Newton. Let me quickly introduce Lawyer Eunice. She's a partner and also a solicitor at BWF Solicitors. Hello, Lawyer Eunice.
Hi, Vicky. How are you?
Hey, I'm good. You're looking Christmassy. I like the, the makeup. You don't usually put on makeup, but I like the red lips and things going on.
Yes.
Wow.
I decided to look very Christmassy because, as you said, tomorrow is Christmas. And I think everybody is looking forward to having not just a lion, but also
Yeah.
celebrating with family and friends
Mhm.
and loved ones. And tomorrow being a Sunday, I know some people will be going to church as well.
Yes.
And so it will be a nice time to just be around people that we know and we love, and just sharing the love of God to everyone, basically.
That's great. That's great. But how has your week been? I know this time of the month, there'll be a lot of pressure on yourselves to try and, conclude on cases, ones that
Yeah,
are, lagging behind,
yeah,
put
yeah.
extra pressure on the home office to try and get things, sorted
Sorted
before
and all of that.
we enter the new year.
I think that definitely you are right in that sense, because
Mm.
when you look at the previous years and how we've always dealt with, should I say, backlogs and workloads,
Yeah.
most of the time when we're nearing the end of the year, we know that there are things that need to be sorted, finished off before the new year starts. And sometimes you even have hearings straight into the new year, and there's no time to be lagging behind. So it's applications that have to be submitted, or it has to be bundles that have to be submitted to the courts and to the home office as well. And so you have to try and get all of those things done
Yeah.
before the new year starts, so that you are not now rushing to do things at that time. um
Mm.
Obviously with the home office, most of them have that flexibility of also working from home, so a lot
Yes.
of what they will be doing is also not just, I mean, doing things in the office where they have somebody pushing them to meet a certain deadline. So
Mm.
they will also be doing a lot of decision making whilst they are home, celebrating with their family and the rest of it. So with the home office, as and when decisions have to be made by caseworkers, they will be making those decisions. And thank God that in the new year, the Ministry of Justice has seen it fit to increase the number of hours that the courts and the tribunals sit to hear immigration cases, especially. Um, there is
Mm.
such a huge backlog, and they are saying that there are not enough judges sitting on cases to make the decisions that are necessary. So they
Okay.
are pumping a bit more money into that area, so that at least cases can be reduced to a certain point, and hopefully not that many people will be complaining if decisions have not been made as yet.
Okay. So should I take it as starting your updates? Is it part of your update? Because I
Of
realized the
course,
direction it was going.
of course, of course, of course. Yes. Yeah, and also in terms of the updates as well, I know that a lot of people um have seen that over the year, they brought in some changes to do with our immigration rules. This may have started when obviously the UK exited the EU, and so you had an introduction of this points-based system for skilled
Okay.
workers and students who would want to come and study and work here in the UK. And they also have introduced new appendices to our immigration rules to
Right.
simplify things a lot more. And so um, you don't have complex paragraphs trying to tell you how you can apply as a family member, or how you can apply as a worker, or how you can apply even to come into the UK. But they've tried to simplify as much as possible so that it is accessible to most people. So, an example even being the fact that those who want to apply under the family settlement route. So you're applying for indefinite leave to remain. You want to be able to see how best you'll be eligible to apply under that route. If you have previously applied for leave to remain as a parent or as a partner or based on your private life, they're saying that all of these can be combined for you to make an application for indefinite leave to remain. Because previously, under our immigration rules, if you were making an application as a parent, you had to be on that parent route up till the 10-year leave was over, or you would
Right.
have to be on the partner route for the duration that you were given. So if it's the 10-year route, you will complete that 10-year route as a parent, or you complete that 10-year route as a partner. And if you had mixed in between, then it would have been that you would have to apply under 10 years lawful residence under our paragraph 276B. But now they've simplified it so that those people can also apply under the appendix family settlement. And you also have the appendix private life for children, especially who have lived in the UK for a continuous period of 7 years, or were born in the UK and have lived here for 7 years, or have lived here for more than half of their life and are between the ages of 18 to 25 and are looking to show that they have lived here or resided here lawfully for at least 5 years before making the application for indefinite
Okay.
leave to remain. And then also introduces those who have also lived here for 20 years or more and are looking to apply for their leave to remain, or if they've lived here for less than 20 years, the human rights claims that they can make in order for an application to be considered under the immigration rules appendix private life. And you have um, appendices, even like the appendix English language, where it introduces those who have GCSEs or A levels in this country, and therefore
Right.
they don't have to do the English language test. And it's not just dependent on having a degree or having a PhD. You can
Okay.
rely on your GCSE or your A levels, which you took in English here in the UK, to be able to say you meet the English language
Language.
requirement as well. So there have been quite a number of appendices that have tried to simplify things as much as possible so that it is easily accessible to people to be able to also understand the law a lot more better than before. Um, yeah, and then when it comes to things like making applications for appeals. We all know that once a decision is refused from outside the UK, you have 28 days. And when it's within the UK, you have 14 days to lodge an appeal. And most of the time, like we said, there are directions that have been given by the court. During the COVID, we know that the courts had guidance for both the tribunals and to practitioners such as ourselves as to when those bundles can be prepared. So when we say bundle, it means documents that were used for the application or documents that you would like for the court to have a look at, including your statements, and also to be able to show to the court why your application should not have been refused. So, in so doing, the directions were that you can upload your documents or prepare the bundle with your skeleton arguments within 42 days of the court acknowledging your appeal, or if the Home Office representatives had produced their bundle by a certain time, then you had that 24 days to also provide the court with your bundle. And so those guidances have made it, should I say, a lot simpler for the courts, because we now have a system in place, which is the HMCCS system, to be able to have documents uploaded to both the court and the Home Office at the same time. And there were some applications such as the EU settlement scheme appeals,
Yes.
which could not be done online, and they had to be done on paper. But now they've introduced it onto the HMCTS online system, so that those applications can also be appealed or lodged online. And then obviously documents can be uploaded as well, just to make things a lot more simpler as well for both sides. And I think that as time goes on, a lot of these things will become very digital. So somebody was asking during the program this week, why is it that my leave to remain goes beyond December 2024, but my card states 31st December 2024? It's just because as the um, system is changing and we are becoming more digital, the UK wants to move with the times, and it wants to be able to have people's leave more electronic than on
Okay.
the card. So yes, your leave may be ending sometime after December 2024, but it is just to say that because the UK government wants to digitize the information that they have, they will not necessarily want you to be having a card on you once that date is up. So you will not need the card, or you will not need the biometric once things have become digitized. So you could travel and everything is on their system, and they know that this is the leave that you have been granted. And most of the time, most people have letters that show or should state what their leave is. So if your leave is ending in 2026, it will state valid from this date to that date. So you will also have a copy for yourself, and they would also have a copy on their system as well, just to make things easier and simplified in a way as well. So yes, that is for those who may have biometric cards that have leaves ending in December 2024, but in real fact, their leave is ending after that date. So that's also
So, Lawyer Eunice, does that mean they are going to, like you were saying, after 2024, when their leave expires, would they be issued a replacement? Because wherever you go, you are expected, it's your ID, isn't it?
yeah,
So, what do
yeah.
you have physically to show?
So I was just saying that, especially for those who are traveling,
Yeah.
it helps if you know that you have a letter that states that your leave is from this date to that
Okay.
date.
So, you can
Because
use the letter.
yes, so
Right.
your
Right.
letter is your evidence that your leave is
Okay.
ending on so and so date.
Okay.
Obviously, for another country, so let's say that you're going into another country. If you're not a British citizen, or even if you're a British citizen and you need a visa to enter another country, you have that visa to be able to show that this is who you are in your passport, and this is your permission to enter into that
Okay.
country. So the biometric card only becomes necessary when you're coming back into the UK.
I
So
get it.
once you are in the UK, they have it on their system that your leave starts and ends on this date. So
Yeah.
you don't necessarily need to show the card.
Okay. All right. Okay. Right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors with your host, Vicky Newton, and our guest lawyer, Eunice Champong, who is a partner and also a solicitor at BWF Solicitors. Today, we discussing what happens to a person whose document submitted during an application is found to be false. We haven't delved into this topic yet. Lawyer Eunice was taking us through some updates for the week. So we are now going to delve into this topic. You are welcome to this show once again. If you want to join in this program, I would love to hear from you. You can do so on our social media handles, especially on Facebook and YouTube at BWF Solicitors and also Vicky Newton. If you prefer to contact me live in the studio, of course, you can do that on 0744 8619711. The number again 0744 8619711. And I'll be able to pick the call up or read your messages for Lawyer Eunice to answer. So, Lawyer Eunice, I know when someone gives a definition of false representation, Home Office have their own definition as well. So we want to hear from you, what is false representation under the immigration rules?
So, more specifically, when you look under our Part 9 of the immigration rules, which is paragraph 9.7.1 to 4, 9.14, it talks about false representation, false information, and false documents that are usually, in a way, seen to be ways in which the Home Office can refuse your application. But specifically, when you look at our interpretations or definitions under the immigration rules, when it talks about false documents, it's talking about a document that may be a counterfeit, that may have been falsified in a way for immigration purposes. It could also be a document that has been altered, changed, amended in a certain way. It could also be a document which you have obtained falsely. So you have gone out of your way to get that document, which is also seen to be a false document. It could be even a passport that you have obtained from some other person, and that person may have obviously falsified that passport in a way or one way or the other. So it's not just to do with whether you have done that yourself. It might be somebody having done that on your behalf,
Right.
it's still seen to be a false document. So anything that is a counterfeit, anything that has been falsified, anything that has been obtained for immigration purposes, that obviously to be false and not genuine, all those come under false documents when you look at our interpretation under the immigration rules. And so it's important that when you are submitting documents, it's always good to have some evidence that these documents are also genuine, because most of the time, let's say for instance you have a marriage certificate. If you have a marriage certificate, what happens is that the marriage was conducted whilst both of you were present. So if it was conducted whilst both of you were present, and it's a registrar that is conducting that marriage, definitely the registrar's name will be there, his signature will be there, the name of the registry will also be there, their stamp will also be on there, and your name, I mean, the bride, the groom, their names will also be on there. If they were witnesses, they will also sign on their marriage certificate, and all of that has to be present. And the registry will not just give you one copy, they will also retain a copy on their records. So if, for instance, you come and you say, oh, the documents, marriage certificates that you gave me, for one reason or the other, I can't find it. So can you give me a record of that? They will be able to produce a record of that for you because they have it on their records that on this day, so and so came with his wife or with her husband to come and get married, and this marriage was conducted here at this registry. And so even if any third party wanted to find out if that is true and they found, it will be on the records as so.
Yeah.
So
Yeah.
it's important that things like that, we take them seriously, because you don't want a situation where they will come and tell you that the document that you have is not a genuine document. And so it's important that whatever document or information that we are giving out there, it seems to be genuine. And not disclosing certain information as well is also seen to be given some sort of false representation, because in a way you are not saying that it is what it is. And so they also feel that maybe that person could be hiding something if they are giving you that information as they don't know or they're not sure. So it's also important that in certain circumstances, if you are not able to give the information, explain why not. And then that way it helps the caseworker looking at it understand your side much better. So yes, in terms of false representation, it includes all of these different things when the Home Office or the caseworker looking at your case is looking at whether there has been some false representation in you submitting your application in one way or the other.
Okay. Right. Lawyer Eunice, I just had this thought. The applicant has in their possession these documents. Unknowingly, are not aware it might be a false document. As an applicant, how do I make sure these documents are not false? We have to do our own due diligence. How do we do that? Do we ask the solicitor to check and verify, or can I, as an applicant, do that? And if so, how do I do that to make sure that
Yeah.
documents that I have in my possession, pardon me, is not false? Or maybe you might not know as a solicitor,
Yeah.
I might not know, but when the Home Office goes through their checks and it's picked up, that is when they get back to the client or the solicitor representing the client that this birth certificate is false.
Yeah. I think the question you've asked is a very valid question. And so a lot of the time, the Home Office just have this probability window. They either have to find that more likely than not your document is not genuine. So a lot of the burden lies on you as the applicant to show that the document that you have is a genuine document. And so, like I gave the example of the marriage certificate, let's even look at a birth certificate, for instance. So you've got a birth certificate in your possession, and a lot of the time the Home Office would say that if you have a birth certificate which was not registered during the 12 months in which you were born, there's a study or research done by an American research team, and apparently they think that some of our birth certificates are falsified documents, and therefore the birth certificate that you have is also falsified because it was not obtained during the first 12 months of your birth. And a lot of that is wrong, because now we have a system, especially in Ghana, where they would say to you that because everything is being digital or we are moving to the biometric system, most people can no longer rely on the birth certificate they were given when they were born, but they will have to now have the biometric birth certificate in order to even obtain a passport and do other things as well. And so, if that is the case, then that birth certificate will definitely be something recent. And if you were to produce that for a foreign application, they will likely say that it's a falsified document. But we can't allow them to say that, because your registry in which you went to have this biometric birth certificate done would have done their checks in order to produce this document to you. And it's good that our PNDC law in Ghana also states that if the applicant or the person going to register their birth has, for one reason or the other, come to the registry and stated that they want a birth certificate, they have to produce certain evidence to show that they were born on so and so date, and
Okay.
having given the prescribed fee and the evidence, they can then obtain a birth certificate from the relevant registry. So it helps in such cases that the lawyer may know what the law says and then include that in the application for the Home Office. There are other documents like the marriage certificate or even bank statements where the registry or the bank itself can put their stamp or they can give a verification letter. And so that one can be obtained by, the relevant applicant who is making their application. And it's very important, especially even when you're committing yourself to making such an application, that you also look at things like specified evidence under the immigration rules, which suggests that even when you're getting a bank statement, you have to make sure that the bank statement is having the logo and the letterhead of
Yeah.
the
Yeah.
bank. And if it's been printed out, it is stamped on each page. And all of that information is relevant to the caseworker, because they want to know that it is indeed a genuine document that has been obtained. And so a lot of it may rely on the applicant, and some of it, which may be law, the solicitor or the legal representative can state on your behalf. But a lot of the time, I don't think some of it is also done to lawyers. I think most of it may be down to the applicant themselves as well.
Right. So, Laura Eunice, what then is the difference between a mandatory refusal and discretionary refusal?
So, like we've been talking about, there are certain things that, of course, the caseworker will be looking out for when they look at a document and they think that it is falsified or is a counterfeit or has been obtained falsely. Those things usually, when you look at our paragraph 9.71, it talks about the fact that if a document has been presented to be a false document or information, or information which has not even been disclosed, is found to be, should I say, false in any way, shape, or
Yeah.
form, the caseworker may refuse that application, whether the applicant submitted it knowingly or unknowingly
Really?
as part of their application. And so, obviously, you know that the caseworker has that discretion to either grant or to refuse. And most of the time, they may refuse the application.
Okay.
And when it comes to mandatory refusal, under our paragraph 9.72, it talks about the fact that where a document is seen to have been submitted falsely, or for one reason or the other, a false representation has been made, and the caseworker can prove that more likely than not, deception was used in submitting that false document or that false information as part of the application, then the application must be refused. And so the word must obviously shows that there is that authority for the caseworker to definitely refuse the application. And in such cases where they know or they are likely to think that that application or document was made using false representation, they will say to you, your application is refused because we believe that deception was used, and deception has to do with whether you know that that document was false. So they're telling you you knew that the document was false, and therefore we're refusing the application, and that in turn is likely to cause your other applications to the Home Office to be refused, and a 10-year ban will be applicable because they are saying to you, you knew what you were doing was wrong, and you still went ahead and did it anyway. And so, with the mandatory refusals, you have that 10-year ban coming with it. And then also, it makes it very difficult to make any form of application afterwards, because they know that this is somebody who has purpose to circumvent the immigration rules in one way or the other. And you don't want to be caught up in that, because obviously, even after the 10 years, something like that is likely to come back, but they will have to address those reasons. So if you're an applicant and you are in such a situation, then it means that you have to address those reasons. And if you think that deception wasn't used, maybe it could be that you didn't know that the document was false, like the example that you gave. You didn't know, you submitted the application, and now they're telling you the document is false. Not only is the document false, but they believe that more likely than not, you also knew that the document was false. So that's deception.
Oh, but Lawyer Eunice, they cannot, honestly, I have to defend the applicant if the applicant is not aware.
So you know you're not aware.
Cannot decide. No, you cannot tell me that I knew. No, I have to be given the opportunity to defend myself.
So yes,
so by defending myself, you will ask me, where did I get the document? So I'll tell you or give you information on where I got the document.
Yes.
So sometimes you know the Home Office have to give us the benefit of the doubt.
But
to proving guilty, you can't just tell me that I knew. Like
So most people are passionate just as you are, because they feel that why would they assume that I've used a false document and then go on and assume that they think I knew that it was false, and that's why I submitted it. And so a lot of the time I understand where you're coming from, because that's how most people feel when they see those refusal letters, and they panic and they are feeling like their world is crumbling. And in such a situation, most of the time, if it's not a human rights application, so for instance, if it's not an application where your private and family life is being considered, or your rights to join your EU family member here in the UK, or to continue residing here in the UK with your EU family member, or having to do with a British deprivation, those things don't come with the right of appeal. And so it's very difficult to then challenge what they are saying. But we all know that we have judicial review in terms of cases where you may not have a right of appeal, and that is usually seen to be a last resort where a government agency such as the Home Office may not have acted dutifully in making that decision because there
Okay.
are other factors involved. Maybe it could be that there should have been more emphasis on certain areas within your application that you think that the law would have given you
Yeah.
much more um, clarity and would have allowed that caseworker to consider all the facts of your case rather than just the one. And then you have the caseworker also having the right to also look at your application through administrative review. And
Mm.
so that means that it can go back to them if you give them reasons to consider your application again, they can reconsider the application again in that sense. So
Mm.
when it comes to challenging them, you at least have that option, but they also come with time limits. So
Okay.
something like a judicial review, usually you would only have 90 days from the date of the decision to be able
Right.
to bring something like that. It's a
Mm.
very expensive choice, though, I must say. And it's something like an administrative review, which is the decision and your reasons going back to the caseworker. Uh,
Mm.
if it's something that was received from outside the UK, you have 28 days. If it was within the UK, you have 14 days to make them aware of your reasons,
Mm.
and then they can look at that and then see how best to come to a different conclusion if they believe your reasons
Mm.
are reasonable enough. Yeah.
Okay. Right. Anna is sent in a question. It says, having lived in the UK for about a year, I was sent a letter cancelling my permission to stay in the UK because they believe that the certificate I presented from the university back home is false. They have given me a number of days to respond. What can I do?
Okay, so this is somebody who has lived here with permission for a while, so it's 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 a in a way it's a good thing. So
Mm.
they're saying that they've now received this letter saying that the certificate that they received from back home is false.
Okay.
Um, in a way, they're telling you that we are going to um, basically cancel your leave because if your document was false when you first presented it, then you may not have the opportunity to remain here any longer.
Mm. Mm.
At least, like I said before, if um, it comes under something that is discretionary, so the document is seen to be false, the caseworker has that discretion to either have the reasons that you have put forward and say that, okay, they will no longer cancel your leave, or if you don't have reasonable reasons why they should not suspect that your document is false, then they
Mm-hmm.
are likely to go ahead and cancel your leave. But
Okay.
if, for instance, in her case, like, she hasn't really said um, what else they have said about her certificate.
Certificate.
Sometimes they may have gone ahead to go and verify it by calling like the university and then
Yes.
saying that we are verified with your university so and so, and therefore we believe that the document you presented is false.
Mm.
In that instance, obviously, if that verification has been done and you still think that they are wrong, you go back to the university and you say,
Mm.
well, this is what they have said, but I know I took this degree and I had this certificate. I need you to write a letter stating that I, student so and so, with this student number so and so,
Yeah.
completed this course from this year to that year, and I graduated with, let's say, a 2-1 or whatever degree on this date, and I need you to verify it with your letter on a letterhead for me to submit as soon as possible. So you have to go ahead as the applicant to be able to get that verification letter from the university. Most universities who have deans or vice chancellors and the rest, you will need somebody high up in authority to sign that letter for it to be taken seriously. If it's the case that, of course, the document is a falsified document and
Mm-hmm.
your leave is cancelled, they will give you a period of time. If it's the 14 days, then you need to be able to make those representations that you did not know that
Yeah.
that document was a false document. And therefore, if you had taken a degree and the certificate didn't come the way that you expected, because maybe you went to the university and they gave it to you and you thought that was a genuine document, then of course you will have to say that I went to the university to collect it. I didn't know that it was a false document, because originally when I went to the university and they granted it to me at a graduation ceremony, I lost that certificate. So what I went for, I believed to be a true document, and therefore I didn't know it was a false document that they were giving to me. And therefore, you have to make those representations to let them know that you did not know that the documents you were submitting was a false document in that instance.
In
So,
relation to that, I think
mm,
a couple of years ago there was a clampdown on colleges and some
mm,
private universities. So
mm,
just
mm.
imagine if you graduated from those universities, where do you go for the reference to check?
Yeah. Yeah, yeah. And so obviously you have to let them know that those universities have closed down and you did not in any way think that you were being given a falsified document.
Yeah.
You genuinely thought that the document that you were presented with was a genuine document. And since the university has closed down, there's no way in which you would be able to go back for them to verify that the
Mm.
document you were given was a genuine document. And you have to be able to present yourself in such light that obviously, yes, maybe you may think that it's false, but I did not know. I did not think that I had a false document. I genuinely believed that I had a document which was true, which was genuine, and that is why I presented it. And so you also have to put those reasons forward for them to consider and then make their decision. Yeah.
Okay. All right. Okay, ladies and gentlemen, the show still goes on. I would like to get more questions from you. If you've just joined us, this is Hanging Out with BWF Solicitors. BWF Solicitors is one of the top. If I should say, I'm allowed to say it, top law firm in London. We have with us the partner and also solicitor of BWF Solicitors, Lawyer Eunice, who is taking us through our topic for today. Is in relation to representation of false documentation, how to avoid that. And we've gone through some of the few questions. She explained to us what it is and also the difference between mandatory refusal and discretionary refusal. Please send in your questions, and Lawyer Eunice is here to answer all your questions free of charge, free consultation. If you prefer to call us live in the studio, you can do so on 0744 8619 711. The number again is 0744 8619 711. You can also send me a WhatsApp message. I think I'm getting a phone call coming through. Bear with me. Let me check who this person is. Be calling to contribute to the program or ask a question?
Ask a question, please.
Okay, and your name and where are you calling from?
I'm calling from London. I'm Nana.
Nana. Welcome to the show, Nana. Okay, your question to Lawyer Eunice. Lawyer Eunice, can you hear Nana clearly?
Yes.
Okay, right. Nana.
Thank you, Lawyer Eunice. We bless you for all that you've been doing for us. My question is, if, for example, you want to bring your partner from home, and he's a businessman, do you still have to do money transfer to him? And
Okay.
another question is, if another person is marrying from within, I mean UK, do you still have to qualify for the 18.6?
Okay. So in terms of the first question, where your husband is a businessman and he earns his own money, if you are somebody who is well-to-do, there's no evidence or there's nothing to say that you need to be sending money to your husband. They just want to know that your relationship with him is genuine. So if you travel and you go and stay with your husband, you have pictures together, there's evidence in your passport that you went there, and they want to see things like that to be able to show that you are in a genuine relationship. It's not necessarily the money transfers to the person. If it's the financial requirement and the person is coming from outside the UK, then they're going to be considering the income of the person here in the UK. So even if the person who is outside is a businessman, the income of the person here in the UK is the only evidence that they will consider. So they will be looking whether the financial requirements is met, considering that person who is here in the UK's income. So if their income from employment is less than the 18,600 a year, then it means that they would need other evidence to show that they will be able to meet that requirement. So it's important that that person who is here in the UK can meet it. And if, for instance, you are saying that a spousal application, so the second question is, if you are making a spousal application for somebody who is already here in the UK, then you have to be able to also consider that, has that person already got leave? If
No,
a person, pardon,
hello, I'm still listening.
has the person
Yeah,
who
that
is
was
already
my
in the UK got leave, or they don't have leave?
They don't have anything.
They don't have anything. So what happens is that what happens is that usually, because they would say that there needs to be insurmountable obstacles to that person applying for their leave to remain in the UK, therefore that person needs to go back home and make the application from back home if they are relying on a partner. Unless you are saying to me that the person who is here as a British citizen or who has indefinite leave to remain has children who are under the age of 18. If they have children who are under the age of 18, then that person who has not got leave can rely also on the children to be able to make that application whilst he's in the UK. Otherwise, they will have to go outside of the UK to make that application.
Okay, please, thank you very much. Can I ask another question? What of if the person has got 2.5, but the child that he based on to get the 2.5 years is the mother is no more applying for the guy, but
Okay.
the person has got a bit of like maybe 2 months or 3 months leave to remain on his visa. Can the person marry here?
So yes, if the person has leave to remain in the UK, then they can rely on another partner, because you are saying that they were a parent, and unfortunately they need evidence to be able to apply for the next leave to remain, and they are not able to get it. So the mother is not going to support, and they would not be able to get evidence from the children to be able to say that they are playing that parental role in their child's life. Then, of course, if they are in a relationship with somebody else, they can rely on that partner to be able to make the application that they are in a subsisting relationship with a partner who they are married to. Otherwise, they will have to show evidence that they have lived with that partner for a period of at least 2 years.
Okay, is your question answered?
Yeah, and the last one.
Oh my days, I have to charge a consultation now. No, this is not buy one, get 3 free. Go on then.
The last one is, if the one you are going to bring from Ghana, the relationship have just begun, is 6 months evidence or 7 months evidence enough for you to go on to do the application?
So one thing that I always say is that as part of our immigration rules, they require you to have met this person. So if you are in a relationship with this person and you haven't met this person and they are doing the marriage and everything for you and you're going to make the application, they are wondering, is this relationship actually genuine? We can't tell because, the Western system and the way that relationships are is so different to the other countries. So, I mean, in the Asian culture, a lot of it is arranged. They will say that this family is asking their son to marry their daughter, and they do all of that. And so they are aware that there are arranged marriages, and that is okay in certain cultures. But where you are saying that it's not arranged, you've never met this person, you're married to this person, to them red flags start showing because they can't see how you can get married to somebody who you have not really met. Yes, we have online system.
Lawyer Eunice, this
Yeah.
one, you have gone home. It's just that the
Okay.
relationship has started and you want to
Okay.
build. You have gone home, you have pictures when you went home, you've met
Okay.
the person. So you've started building your evidence. So I just want to know the length of time.
Okay.
6 months or
So
7
is
months
it enough?
evidence,
Okay.
it's enough for
Okay.
you to do the application.
Okay.
Of course, if you are saying that you've met this person and you have fallen head over heels in love with this person, then that's fine. As long as you're not saying that the first time you met him is the time you went to marry him. So those two have to be separate. So if you've met this person and you genuinely have a love for this person loves you, it will all show in the messages, in the telephone calls. All of these things will show because you are going to show that to the caseworker who is making the application. If you don't have any evidence to show that this is how genuine your love is for this person, then that will become difficult. It's all in the evidence that you present. So yes, even if it's 7 months and you have enough evidence to show them from your messaging, your telephone calls, video calls, all those things, then they will look into it and obviously make their consideration from the evidence that you present.
So all those recorded voice messages and all those stuff, they are going to listen to it and then they read the messages.
Sometimes I think it's sensitive. It's private,
so
isn't it?
Things like your phone calls, if you're calling him 5 times a day, your itinerary, the itinerary that you get from your phone company, that
Right.
I called him 5 times today. So the itinerary for the whole month, maybe each day you call him twice or you call him 5 times a week. The itinerary will show the number of times that you call.
But not the details.
No,
of the
you don't
conversation.
necessarily need the details. But there are people who like to message more. So those that like to message more, we always tell them, do a compilation of your WhatsApp messages. So you either share it to your email or you screenshot them and you produce that as evidence of your communication with each other, because it's a long distance relationship. You're not living with each other. So there has to be something. There has to be some form of communication. So they want to see that.
All right. Thank you so much.
All right then. Okay. Have a Merry Christmas. Take care. Bye. Bye. Whoa.
I've seen another question also from Nana Bob.
Okay. If you can read it for us.
Yes. It says a friend holds a residence card expiring 2024. he got pre-settled status. He's of the view that he qualifies for settled status as he has lived here 7 years. He made application for settled status in September this year, but no decision yet. He wants to travel in March until May next year. He contacted Home Office about the decision, but they said decision is not ready as further checks are still ongoing. So in March, if the decision is not in, can he still travel without any issue? Okay, so I definitely would not advise him to travel whilst a decision is still ongoing. First of all, he's made the application under the EU settlement scheme. I know that most applications done under the EU settlement scheme is just a confirmation of that person's status. So what happens is that if you
yeah, is it possible to come back to this question after this phone call? There's someone
okay.
online, please. Yeah.
Okay.
All right. Brilliant. Hello. So what's your name and where are you calling from, please?
My name is James.
Okay. All right. So your question to Lawyer Eunice.
Yeah, Lawyer Eunice, there's a lady who wanted to visit UK as a tourist, and then he used travel agent.
Okay.
In 2019, and then application was refused. Now he got this occupational shortage opportunity.
Okay.
Care sponsorship, and he wants to do the application with her husband. And because she wanted to come on 2019, the agent gave her a supported document, which they didn't register but the agent falsely gave her a marriage certificate. And now that she wants to do the application to come to work in the UK, the lady didn't get the document from the agent, and she had forgotten the information that she used on 2019 application.
Yeah.
So now she got back to she went back to the agent. According to her, she said the office has been closed.
Oh dear.
And now she doesn't have any information. But the marriage certificate that they use, she doesn't know the person, because the agent wanted to use the bank statement to support the lady. So he used that marriage as a supported document to bring the lady. So in this case, what can she do?
Okay, so in such instances,
the original marriage there, and she wants to come with the husband.
Okay, so in such instances, if let's say an agent made the application on her behalf and said she was married to so and so person, and this is the information they are presenting. Yes, they have put that information on the application, but definitely they would have also had a certificate to present when they were making the application as well. So with the copy of the certificate that was used, if she is able to go back to the registry, let's say that they went to Kumasi Metropolitan Assembly to go and get that certificate, she will have to go back there to say that she wants a copy of that so that she can obtain a divorce certificate. Because what she will need is that.
That's where the problem is, because the agent designed the marriage certificate by himself.
So that means he manufactured the certificate. So why go ahead and look for that certificate? I don't think that will favor.
So does she have evidence that it was done by the agent, or she's assuming?
What I mean is, they don't have that record in the.
Oh, okay, at the registry.
Oh,
Yeah.
right.
Okay,
Yeah.
okay.
So they don't have the record because that was a false
Exactly.
document. Yeah, that was a false document. And the lady didn't get any copy of the documentation.
Okay.
So now, Home Office has the data of that application.
Yes.
Yeah.
So but she doesn't have the information.
Yeah.
Okay, I understand where you're coming from. Okay, so in that
registered at the register, yeah. So they don't have the record.
Okay, so in that instance where they're saying that there's nothing of that sort on their system, so from what you are telling me, if the registry is saying that there's nothing of that sort, she just gets a letter from the registry because the information that was put on the application says that you were registered at Kumasi Metropolitan Assembly. Then you just get a letter from them saying that there was no marriage of that sort at the Kumasi Metropolitan Assembly, and she will provide that letter as evidence that no such marriage ever took place, and therefore the document she did not know was a falsified document until she went back to get a document which stated that they didn't have any record of that sort. And she will need a lawyer to help her in that instance, because obviously you are saying that the document was false. You didn't know that the document was false, and therefore you need to be able to show. Instances like that, there are so many case laws that talk about the use of false documents and them also presenting the applicant with the opportunity to give their response where that information or that document that was presented was not known to them. So it could be that it was presented on her behalf, but she didn't knowingly produce that false document during the application. And so you have cases such as Panda and AA Nigeria that talk about that person having that opportunity to respond in such instances. So yes, she will need legal representation if she's obviously going ahead to say that she was never married in the first place.
So now you committed that you lied to Home Office.
So she's basically saying that a false representation was made in that instance, but now she has to say that she did not know.
Yes,
that she was submitting that document because it was obviously something that she obviously knew to be a genuine document. I don't know whether she presented it herself or the agent presented it on her behalf.
It's the agent.
But when we are going for the biometric, I think they handed over the document to you to present it before you.
So it also depends whether she handed it over or they uploaded it, because some people upload.
So you mean you didn't know that this certificate was on your document?
So that's where the issue also lies, because where, for instance, the person has gone there physically to present that document, and then you are saying to them that when you went, you were presenting a marriage certificate. You didn't know that you were presenting a marriage certificate when it was being signed.
You even said to them that your husband is supporting, is sponsoring your holidays.
Yes. So if in that instance that has all been said, then you can't say that you didn't know that you were not married. So she has to be careful in the way that she obviously will present that information.
Okay.
Yeah.
All right.
Yeah.
So
it's better for her to engage the services of a solicitor, so they would know how to approach the Home Office. Try and see how best they can defend it. It's going to be difficult, but I think a solicitor will, try their very best to see if that can be overturned.
Yeah.
Oh, okay. So I was the one filling the form.
Okay.
For her because you got the sponsorship for her. Okay. So in this case, I will come come and see Lawyer Eunice and then
please
find
do.
out how. Then in this case, I will not submit the application.
No, don't.
Yeah, I haven't done the submission.
Okay.
So I'll wait.
All right.
Thank you very much.
Wishing you all the best. Yeah. Take care. Bye. All right. So, Lawyer Eunice, could you please take us through the question? Then please give us the answer, the explanation to that.
Okay. So I think he was saying that he has pre-settled status. He's applied for settled status because he's lived here 7 years. And he wants to know whether he can travel in March, even though a decision hasn't come yet. So in that instance, I don't know on which basis he made the application, whether he made it on the basis that he's a spouse or he's a dependent. I can't tell. But I was explaining that when it comes to our EU settlement scheme, it is a confirmation of your residence here in the UK. So a lot of people who previously had residence cards under the previous regulations, which is our Immigration EA Regulation 2016 or 2006, would have had a biometric residence card that says this is a 5-year residence card as a spouse or as a dependent or whatever it is that the person is applying as. And that card would have remained valid even if they applied onto the EU settlement scheme. So the card that they previously had, if it had not expired, and in this instance, it says that the card that he has will expire in 2024. So I'm not sure whether it's the old card or they've now got a new card, because I'm not sure. So I'm just assuming that maybe it's the old card under the previous EEA regulations. So if it's the old card under the previous EEA regulations, it will still be seen as valid, even though they've got this new EU settlement scheme confirmation. So that's what gives them that pre-settled status. Of course, if they are making this new application as a settled person, I'm not sure whether they qualify because I don't know what the facts of the case are. But obviously, if you have an application in the UK and a decision has not been made, it is never advisable to travel whilst the application is still ongoing. You always have to wait for a decision to be made before you travel. You would find out that in most applications under the immigration rules, it would tell you that once you travel, automatically it's like you are saying that the application should be withdrawn because you are basically telling them that you have leave to continue as and when you should. So definitely do not travel whilst your application is pending. Wait for a decision to be made and then you can go ahead. This is totally different from applying for a replacement biometric card because it's not to do with your leave to remain. So if it was a biometric card application and you were just waiting for the new biometric card and it's an emergency that you have to travel, then maybe you would have been able to travel without having to wait for the new one. But in most instances, if you've submitted an application for your leave to be extended or to be renewed, please never think of traveling until a decision has been made. Yeah.
Right. Okay. To our last question, I think I wouldn't take any more questions. This lady says she has a niece in Nigeria who has applied to come on a visit to the UK a number of times and was always granted. She then applied to come and work in an engineering company. However, her application was refused because it was stated that her bank statement was found to be false, and therefore deception was used to obtain her visa. A ban would therefore be applied. Is there anything she can do? Why was this not picked up when she was, visiting the country in and out for that period of time?
Obviously, when you're applying for visa, visa, the documents you present will be totally different from a document you will present for a skilled worker visa.
Right.
So
right.
if you're obviously coming on a visit and probably you're relying on somebody to sponsor you, those documents will definitely be different from the documents that you would use if you're applying as skilled worker. Or maybe she has changed banks. So the documents will be different from the visit. But going back to her question, it's very similar to the gentleman who also phoned, where you are told that documents that you submitted may be false. In this instance, they've told her that the document is false, and they also believe that she used deception. So not only is the document false, but we think you knew that it was false and you still went ahead to submit it as part of your application, and that is deception. And so in that instance, they will also say that they have refused your application, and that is where the mandatory refusal comes into play. Like I was saying before, usually, unless there's a human rights claim where you're saying that you're making an application to probably join a family member, or you're coming to join your EU spouse or family member, it's very difficult to have a right of appeal. So in such an instance, the only resolution is to basically apply for administrative review. And you want them to consider your reasons. You want to be able to respond so that they would know that you did not knowingly present that document. It was never your intention to produce such a document if you knew it to be false. And because you did not know that document to be false, you are therefore making the application. You are making that request for administrative review to let them know the basis for which you presented those documents and that you did not know that it was a false document. So, yes, in that instance, I think that it will be beneficial for that person to respond by administrative review, and then the caseworker can consider whether it's a discretionary refusal or they would remain at the mandatory refusal. At least if they say they still refuse it because you used a false document, it is better than them refusing it on the basis of that mandatory refusal where deception was used.
Okay. Okay. Yes, I have another caller on the line. Hello, caller. Your name and where are you calling from, please?
Hello, my name is Kwame. I'm calling from Manchester.
Hi, Kwame. Okay, Lawyer Eunice is here. Ask your question.
Okay, Lawyer Eunice, sorry to disturb you this afternoon.
Oh, you're not disturbing us.
So, my question is, I'm married to EU citizens, and have got my indefinite leave to remain in the country. And then even though our marriage is a bit of late, like we are living separately now, but we haven't done the divorce yet. But I found out my partner got a boyfriend now, and then she traveled with the boyfriend, and they were questioned at the immigration when they were coming back. Because we haven't done our divorce certificate yet, and then I want to find out, would that have an impact for the both of us, or we can do our divorce now or without any issue?
Okay, so in this instance where you are saying that you have both separated, I'm sure she probably would have said the same thing when she was questioned at the airport when she arrived with her boyfriend as well. When it comes to our Appendix EU, because a lot of the EU regulations were transposed into our Appendix EU due to the withdrawal agreement. So the same things will apply. So if you're saying that you're separated and you want a divorce, you can only retain your rights where you can show that the marriage at least lasted for 3 years. as long as you are able to show it lasted for 3 years, you both lived or resided here in the UK for 1 year, and that both of you, whether she was residing here, you were residing here, you resided here for that period of time, yes, and that you are still residing here in the UK. So all of that will be considered when you say you are retaining your rights as a family member of an EU citizen. And they want to know, did she have permanent residence? Was she working here in the UK for that period of time before you separated, or should I say before divorce proceedings was finalized? And did you continue to also work? So you have to be able to show that you have retained your right. And if you are saying that,
if I can make a correction, sorry.
Mm-hmm.
So I am married to the EU citizen, which I've got my indefinite already. I've got the settlement already.
Okay.
So after our settlement, I think after 3 months, and then we decide to go on our way. So now she's living with somebody, and then doing her own thing. I'm doing my own thing, but we haven't done the divorce on the paper. And then she decided to travel with a new boyfriend whilst we were separated, whilst I've got my indefinite already.
Okay. So then, of course, at any point in time, you can divorce, because you are saying that it's something that you have both agreed, and you already have your settled status. And so at any point in time, I think that you should go ahead and then apply for divorce.
Has she answered your question, Kwame?
Yeah.
Okay.
Yes, it's clear.
Okay. Yeah. All right.
So, yes, everything is clear now. So I was a bit worried because she was pushed at the airport. So I was in the future, if we've still not done the divorce yet, and I'm coming back, maybe I will also be questioning.
Definitely, you will be questioned. Yeah, you will be. So it's better that you start with the divorce proceedings so that you don't fall into that same trap, because it's something that will be on their system.
Is that okay?
Yes, that is
all
okay.
Right.
Yes.
Okay then.
Yes. Thank you
all
very
right.
much, lawyer.
Okay. Yes. Wishing you all the best. Take care. Bye-bye. So on that wonderful note, Lawyer Eunice, we'll have to,
wrap up.
Just quickly summarize what we've, talked about today.
Yeah.
And definitely, I've been getting lots of messages, people wanting to get in touch with you. So if you can, please give us your office details. If possible, let us know when BWF solicitors are going for the break and when they are resuming. I know you are not working tomorrow, but if you could tell our viewers when BWF solicitors will go on a break and come back for the new year, so that people are aware and can make contact and book appointments.
Definitely. So yes, we've been talking about false documents being used in applications, and it could be applications here within the UK or from outside the UK. And it's important to also realize that if a false document has been presented, the caseworker looking at your case can refuse the application based on a discretionary basis or a mandatory basis. And that's usually if they believe that a document or an information has been presented falsely, obtained falsely, or it has been altered or changed in a certain way, or even so obtained for immigration purposes based on false means. And so when it comes to such documents or information, it's important that the caseworker who is looking at the application may decide to refuse the application if such a document has been presented, whether knowingly or unknowingly. If it is seen that the application was presented with those documents or with that false information, and the caseworker believes that it is more likely than not that you knew or deception was used in presenting that information or that document, the caseworker is obligated to refuse your application, and that's where the mandatory refusal comes into play. And in that sense, if it is refused, it would usually come with a 10-year ban. But in any instance, they should provide you with the opportunity or the should I say the means to be able to respond and give your side of the story.
Yeah.
And so those are what we've been talking about. And because it's also a technical area and there are so many case laws to deal with, I wouldn't advise anybody who is dealing with such a situation to do it on their own, because you have to be able to present your reasons in a coherent manner, where the person is likely to see that the reasons you've put forward are reasonable and they are justified, and therefore there is no way in which you were able to present those documents knowing that those documents were false. And so that is in brief what we've been discussing today. As we've had so many calls and I know there are so many questions to do with this area, I will leave my details, and hopefully we should be coming back into the office on the 28th of December. We will have the usual bank holidays off, so we are not in the office until Wednesday, and then we'll be in the office Wednesday, Thursday, Friday next week, and then we're back in the office again from the 3rd of January. So
Right.
the 3rd of January 2023, we'll be back in the office. So yes, our details. We are situated in Seven Sisters. So BWS Seven Sisters, we are on the 4th floor of Anna House, 214 to 218 Tottenham High Road. And our postcode is N15 4NP. So it's N15 4NP. We're usually open from Monday to Friday from 9:30 a.m. to 6 p.m. And we usually take phone consultations or we have face-to-face consultations as well. If you want to speak to me outside of office hours, my number is 075 35 81 3910. So 075 35 81 3910. So yes, Vicky, I think that we have to wish our viewers a merry,
Yes, a very Merry Christmas
and
and
a
a prosperous
blessed New Year.
new year.
Yes.
We are coming back bigger and better. And we've got, I don't want to, okay, I'm not going to say anything. Lawyer Eunice has got some surprises for us for 2023.
Yes, definitely bigger and better.
Exactly. So on that note, ladies and gentlemen, thank you so much for staying with us through this program. We went over the scheduled time, 30 minutes extra, but this program is for you. So if we have more than expected phone calls and messages coming in, of course we have to make the time, for you guys to get your your questions answered. And I believe that you continue to watch Hanging Out with BWF Solicitors and support us. We thank you for all your support from January to December. We very much appreciate it. Without you, there is no Hanging Out with BWF Solicitors, and we sincerely appreciate it. Thank you so much. Continue to support us. Continue to pray for us. And we know we'll come back January 2023 with a big bang. Until then, Take good care of yourself, and we wish you a Merry, Merry, Merry Christmas and a prosperous New Year. Please remember to share. Lawyer Eunice?
Yes. So yes, as Vicky has said, we are wishing you a very Merry Christmas, and we hope to see you well and healthy, and very, very expectant of the new year. Yes. So this is bye for now until we see you next year.
Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.